You survive a violent attack in your own home. You manage to break away, dial 911, and wait for the police to arrive. But when officers secure the scene, they don't interview you as a survivor. They arrest you as the attacker. This scenario plays out with alarming frequency. Research indicates that approximately 700,000 wrongful domestic violence arrests occur annually in the United States. Law enforcement professionals call this victim-perpetrator role reversal. It happens when first responders arrive at a chaotic scene and misidentify the true victim as the primary aggressor. We often assume these errors stem from elaborate lies or false reporting. The data points elsewhere. These reversals are the byproduct of a structural heuristic failure, a breakdown in how first responders process human behavior under extreme stress. We saw this failure broadcast to the world in the summer of 2021. This is the missing person flyer for Gabby Petito. Weeks before her murder, police in Moab, Utah, responded to a 911 call reporting a male hitting a female. Officers stopped the couple's van, separated them, and conducted interviews. Despite a witness explicitly reporting her partner as the aggressor, police designated Petito as the primary abuser. The mechanics of that high-profile tragedy map identically onto thousands of lesser-known cases, including the 2004 arrest of Bruce Whealton, a licensed clinical social worker in North Carolina. Whealton's incident generated a highly specific data footprint. He was the injured party, bleeding from an assault. He initiated the 911 call for help, and he was the individual treated by emergency medical services. Yet later that day, investigators bypassed those facts. Whealton was arrested, still wearing his own blood-stained clothing, after detectives accepted a completely conflicting narrative delivered at the police station by his attacker. In Moab and in North Carolina, officers let their subjective interpretations of behavior override the objective physical reality of the scene. To understand exactly how these inversions happen, we have to split a criminal investigation into two distinct tracks: the objective data and the investigative narrative. The objective data track begins with what forensic experts call time-zero data. These are the immediate, unedited records generated the exact second an incident enters the emergency response system. This environment produces the most critical evidence in any investigation. Time-zero data consists of the raw 911 audio recordings, the computerized dispatch logs detailing exact unit arrival times, and the initial patient care reports filed by EMS paramedics. This triad of documentation captures the scene before anyone has time to rehearse a story. It establishes who asked for help, who was bleeding, and what the physical environment looked like before it was cleaned up or compromised. The investigative narrative track, conversely, is constructed entirely after the fact. It relies on station house interviews and written reports compiled by people trying to assign blame or avoid liability. A rigorous investigation anchors itself to the time-zero data. In practice, the justice system routinely discards the objective baseline the moment it contradicts a police officer's intuition. When patrol officers arrive at a violent incident, state laws often mandate they make an immediate arrest. They have minutes to determine who the primary aggressor is, forcing them to rely heavily on rapid visual cues. A person surviving a violent attack is experiencing a massive biological trauma response. Their nervous system is flooded with adrenaline. They might hyperventilate, shout, act combative out of terror, or completely dissociate and shut down. Police academies train officers to command scenes and demand compliance. When an officer encounters a victim exhibiting a biological trauma response, standard patrol heuristics frequently mislabel that distress as hostility, instability, or guilt. This creates a blind spot easily exploited by a recognized psychological tactic called DARVO. DARVO stands for Deny, Attack, and Reverse Victim and Offender. A practiced abuser executing DARVO knows exactly how to play to law enforcement biases. By the time officers arrive, the perpetrator presents as exceptionally calm, highly rational, and entirely cooperative with police instructions. This matrix charts police evaluations. The x-axis tracks actual threat. The y-axis tracks perceived threat based on demeanor. Here is the inversion zone. Officers see the panicked, injured victim as a threat, and the calm, compliant abuser as a credible witness. Relying on this demeanor fallacy guarantees a catastrophic error. The officer ends up arresting the victim's psychological reaction to the crime, leaving the actual crime entirely unpunished. Once the handcuffs click, a psychological mechanism called narrative lock-in takes over. A subjective guess made in a chaotic living room hardens into official case theory. The initial patrol report becomes an informational bottleneck. Every subsequent investigator reads this document first, priming their expectations before reviewing physical evidence. Detectives inherit these labels blindly. Person A is designated the suspect. Person B is the victim. The premise of the crime is no longer debated. The system only seeks to confirm it. Confirmation bias dictates the rest of the investigation. Detectives selectively hunt for details that support the patrol officer's conclusion, while actively ignoring or rationalizing away physical evidence that contradicts the file. This timeline maps the institutional cascade. As hours pass, the subjective investigative narrative literally overwrites the objective time-zero data. The file moves up the chain. Prosecutors draft charges based on the flawed report. Public defenders advise clients based on those charges. By the time the case reaches a judge, the entire legal apparatus is forcefully litigating affection. The court is operating on the unverified assumption that the first responder's initial guess was flawless. While the prosecution builds its case on the flawed narrative, the original time-zero data, the 911 calls and dispatch logs, sits idle on municipal servers. Standard data retention policies are notoriously short. Many jurisdictions routinely delete 911 audio and computer-aided dispatch data within 60 to 90 days to save server space. This creates a fatal catch-22. Detectives don't request the audio because it contradicts their established theory. By the time a defense attorney identifies the discrepancy and files a subpoena, the deadline has passed. In Bruce Whealton's case, he spent 7 months detained awaiting trial. During that window, the critical first responder notes, the dispatch logs confirming his 911 call, and the EMS documentation of his bleeding injuries were never acquired by the defense. This diagram illustrates how the system processes truth. The subjective police report is archived permanently as an official record. The objective proof of innocence is quietly dumped into the trash. The justice system doesn't have to actively suppress exculpatory evidence. Its standard operating procedures practically guarantee its deletion. The timeline eventually forces the misidentified victim into the courtroom, where they face the final and most dangerous hurdle. The judicial system operates on a baseline presumption that law enforcement performed their due diligence. Judges and juries assume the investigation was thorough and complete. Juries are instructed to evaluate the evidence presented to them. They remain entirely blind to the evidence that was bypassed, ignored, or allowed to expire. The burden of proof quietly inverts. To clear their name, the misidentified victim must prove that the police investigation failed, but they must do so without access to the very data the police allowed to be destroyed. This flow chart tracks a wrongful conviction trap. A flawed investigation requires new evidence to overturn, but the flawed investigation ensured that evidence was destroyed. Facing immense sentences and lacking evidence, traumatized victims routinely capitulate. They accept plea deals to escape the machinery. Modern courtrooms rarely adjudicate the actual facts of a violent incident. Instead, they test the bureaucratic durability of the patrol officer's initial mistake. The damage extends far beyond a criminal record. Surviving violence only to be prosecuted by the state inflicts severe, compounding psychological wounds. Forensic psychologists studying ex-honorees document clinical outcomes defined by total identity destruction, severe depressive disorders, and rates of complex PTSD that test higher than those measured in combat veterans. Clinicians classify this as a distinct form of betrayal trauma. The victim watches the exact institution designed to protect them transformed into a weapon wielded by their abuser. Dismantling this error model requires precise, systemic intervention. 2 specific legal reforms are necessary to break the cascade. First, jurisdictions must mandate the automatic, long-term preservation of all time-zero records, 911 audio, CAD logs, and EMS reports for any incident involving violent crime charges. Second, the broader legal system must adopt the evidentiary standard currently used in Massachusetts, known as the Bowdoin defense. The Bowdoin instruction explicitly permits defense attorneys to argue that the police's failure to collect or preserve evidence is in itself grounds for reasonable doubt. It allows juries to weigh what the police chose not to investigate. The justice system demands rigorous proof before restricting human freedom. Achieving that requires courts to acknowledge that an officer's first instinct is frequently their most dangerous error.